which give him certain function which he has to exercise in his discretion. That is Article 200, and 188 is emergency powers. My submission is that, according to me, the governor shall be a guide, philosopher, and friend of the ministry as well as people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly conferred by this constitution. He will be a man above party, and he will look at the ministry and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is a mere dummy, an automation, or a dignitary without powers is perfectly wrong. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. But there are many other matters in which the advice will neither be available, nor will be bound, nor will he be bound to accept that advice. My lord, thereafter, my lord, Dr. Ambedkar's speech, which I have read, my lord, in a different context. So, my lord, I am not reading it here, but he, my lord, substantially echoed the Mahavir Tyagi view and the Lord, I have quoted Sirvai, my lord. If your lordship can come to, I will not read it. Page 192. My lord, what are the discretionary powers of the governor and the president? My lord, Sirvai has, my lord, H.M. Sirvai. My lord, really assist your lordships. Now, please come to, my lord, 194. Lord, these are the judgments on the question of discretion. Lord, please see 188 at the foot of page 194. It is, your lordship gets that. It is 194.
What?
194. PDF is 101. Para 188. It is submitted that this honorable court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India, and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so-and-so, 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 where he will not be bound by the aid and advice, and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchi Commission, and have been concurred by a 5-judge bench of this honorable court in Nabam Rabia. I'll read, my lord, very illuminating paragraph of Nabam Rabia, where the constitutional courts specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent Chief Minister and his Council of Ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of Council of Ministers, like the case of grant of sanction for prosecution of Council of Ministers. 197 sanction or Section 17 PC Act goes before the governor, my lord, in case of chief minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Samsher Singh. Samsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Samsher Singh's 7-judge bench judgment is taken note of in State of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the. It's not there, my lord. I can't, my lord. In State of Punjab versus Union of India, the 3-judge bench, my lord, 2024 judgment takes note of Samsher Singh, but it has escaped the attention of the bench of these 2 paragraphs, which, according to me, is the real law of them. Lord, your lordships would find, my lord, that judgment at page 11669. Just put a note, my lord. That judgment, my lord, volume 5.29, judgment starts at page 11660.
Volume?
Volume 5.29. At page, it starts at page 11660. Samsher Singh is cited at para 16.
Para 16.
16 at page 11669.
1 minute.
Not only 2 paragraphs are noticed. The lordships may come to 11669. Yeah. My Lord Justice Narasimha has, my lord. My Lord the Chief Justice.
Does it start from 116?
It starts from 11660, but I am at 11669, where Samsher Singh is noted. These principles have been well established, your lordship gets, my lord, since the decision in Samsher Singh versus State of Punjab, where this honorable court held, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. Sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisors to bear responsibility for his action. Those advisors must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, your lordships have, my lord Justice Suryakant has the right copy, my lord, I believe. I thought so, my lord. My lord, volume Roman 5, 29.
From Allahabad judgment is there. 11,670 पेज खोलिए.
Lord, can I give my copy for immediate reference?
यानी मिल गए.
State of Punjab versus Governor.
No, like, yes, go to.
Lord, 11669,
Paragraph 16.
paragraph 16. My lord, I'm grateful. My lord, where
Samsher Singh.
Samsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread, my lords? Or may I read them again?
Yes.
Yes. Under the cabinet system in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the Constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisers to bear responsibility for his action. Those advisers must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a government at the center and in the states and not a presidential form of government. The powers of the governor as the constitutional head are not different. Well, these two paras are quoted. What is missed from Shamsher Singh is in my written submission at page 197. Well, these two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of Shamsher Singh.
And this is what I'm now showing.
54 and 55 you want.
And it's a Shamsher Singh is 7.
66.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, so-and-so, 6th schedule, and article so-and-so, so-and-so. Conferred on the governor means that of ministers in other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of council of ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the council of ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. My lord, now I'll come to that, my lord, and my learned friend also will take assist your lordships on that. My lord, in the judgment of Tamil Nadu, this is distinguished by the Honorable two-judge bench, my lord, relying upon a concurring opinion in this 7-judge bench judgment, my lord. One paragraph of the concurring judgment, I'll come to that. Now, my lord, next judgment is MP Special Police Establishment Act. Again, my lord, 5 judges, and was not noticed by the state of Punjab judgment. Para 11, I'll skip, my lord, the first part. First part gives the facts. What were the facts of that case, my lord, which may not be relevant for the present, but I have put it, my lord, for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of council of ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, so-and-so, so-and-so, so-and-so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion, even though the constitution has not expressly so provided. Mr. Sorabji relies on the Samsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. My lord, para 54 to 56,
which you just read.
which I just read, which my lord, appears to have escaped the attention of the bench in State of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is, my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. My lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in State of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchi Commission's formulation that governors' discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. But 151, the important observation in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled. The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, 5-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163, we endorse and adopt the same as a correct expression of constitutional interpretation with reference to the issue under consideration. My Lord, if your lordships were to see, my lord, how this is dealt with in Tamil Nadu, volume 31, my lords. This is 151, 152. Lord, this Nabam Rabia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords.
Which para?
My lord, page 12432, para 301. The lordship gets, my lord.
Yes.
11301. Lord, another constitution bench of this court in Nabam Rabia had the occasion, my lord. Thereafter,
One page number?
I'm sorry, 12432,
Yes. Paragraph.
12432.
Yes.
Para 301. Another constitution bench of this court in Nabam Rabia. Nabam Rabia is, my lord, taken note of. Then, my lord, the honorable court is pleased to quote 140, para 147.1, 147.2, 148, 149, and at page 12435, Lord, possibly misses 151 and 152, which I read, and comes to 154. And this discussion in Tamil Nadu is directly while dealing with the question of discretion. These two paragraphs, my lord, since, my lord, it escaped the attention of the two-judge bench, my lord, I am placing for your lordship's consideration. Now, my lord, I come to the next judgment, that is B.K. Pavitra. But this is two-judge bench judgment, which is declared.
Just 1 minute. Come back to page 12432. The Tamil Nadu judgment refers to paragraphs 147, 148, 149, and then it jumps to paragraph 154. 151 and 152 are left out.
That's what I submitted, my lord, with profound respect. That two paragraphs seems to have escaped the attention of the bench, my lord. Because from 149, it directly goes to 154. And in my submission, the real law is laid down in 151 and 152. And this is, my lord, while discussing discretion, the point which I am arguing, my lord, whether in all cases aid and advice is binding or there is a room for discretion.
Yes.
Lord, now please come to page 200 of my submissions, my lord. B.K. Pavitra judgment. Lord, this issue was squarely there.
Can you
This-
read the 154 with Tamil Nadu refers to? Underline,
Only a minute.
which comes after 152. They same very page. 154 of Tamil Nadu
Ah.
follows 151 and 152.
He's contained that though.
Lord,
other paragraphs are-
154 is Nabam.
वो दो मिसिंग।
तीन चार पैराग्राफ
बाद में बाद में-
151 and 150.
Lord, 154 is slightly different from 151, 150. It is not slightly, but substantially. Lord, now kindly come to BK Pavitra. Page 200. This is, of course, a two-judge bench judgment, but it is declared per incurium. And I'm not repeating the argument, my lord, but this itself was sufficient enough for a reference under 145.3. Lord, apropos your lordship's very correct, my lord, the proposition, my lord, the Chief Justice says at the outset that in every matter we are not supposed to look at 145.3.
But
at the
as far as justiciability is concerned, paragraph 155.5, Evam Revia.
Yes, ma'am. But 155 will have to be read in context of 151,
Yes,
150.
sir, but then even you read 155.5,
Fifthly,
Take one, two,
the underlined portion, highlighted part. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 163(2) is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission, but this is on judicial review, not on discretion. Rejected advance by the respondent that the scope and extent of discretion vested with the governor has to be ascertained from Article 163(2) on the basis whereof the submission was canvassed. And secondly, any discretion exercised beyond the governor's jurisdictional authority would certainly be subject to judicial review. It was on judicial review. And it is, if it is beyond, but not obviously, if governor.
according to you, under 200, he has an ample discretion.
That's
And
what
therefore-
Nabam Rebia says, my lord. And my lord, that's my contention. He has ample discretion, my lord. Situations may differ. The instances which are given in all the judgments are illustrative, not exhaustive. But they say that it is wrong to say that in every matter, like precedent, he is bound in every matter by aid and advice of the Council of Ministers. Samshay Singh also, my lord, 7-judge bench says that there are discretionary areas, including Article 200. Specifically, Article 200, every constitution bench mentions. That was precisely, my lord, the question in Tamil Nadu. I'm not, my lord, deviating from this point, but, my lord, just to, my lord, kind of respectfully respond, my lords have very rightly said that in every case, it's not necessary that the court would examine 145.3. A bail petition comes, it would involve Article 21, but it won't become a constitutional interpretation question that it has to be referred to the larger bench. But this was a case where only issue was constitutional interpretation. Facts were not, my lord, much in dispute. Anyway, my lord, leave it at that. Please come to BK Pavitra. My lord, para 66. This is, my lord, declared to be per incurium by the two-judge bench, my lord, in Tamil Nadu. I'll show, my lord, that. Where a bill is not a money bill, your lordship gets. Where a bill is not a money bill, the governor may return the bill for reconsideration, upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to the bill, but necessarily reserve it for the consideration of the president if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the president, a discretion is conferred upon the governor to follow one of the courses of action enunciated in substantive part of Article 200, aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for consideration of the president. The substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for consideration of the president. The constitution has entrusted this discretion to the governor. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia versus so-and-so. Where, my lord, 154 is quoted, my lord, I've read, I'll skip that. Then para 67 of BK Pavitra. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for a consideration of the president. They did not give instances, they left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the constitution which justify a recourse to the power of reserving a bill for the consideration of the president. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will to those who elect their representatives. They are the collective embodiment of the will. The act of reserving a bill for assent of the president must be undertaken upon careful reflection, upon a doubt being entertained by the governor about the constitutional legitimacy of the bill which has been passed. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the president. Article 254(2) is an illustration of the constitutional authority of the governor to My Lord Justice Suryakanth has the same 5 minutes. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the president. Article 254(2) is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration of the president in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. Eventually, which is specified in Article 254(2), does not exhaust the ambit of the power entrusted to the governor under Article 200 to reserve a bill for consideration of the president. Apart from repugnancy in matters falling in the concurrent list between state and the parliamentary legislation, a governor may have sound constitutional reasons to reserve a bill for consideration of the president, apart from the repugnancy issue. Article 200 in its second proviso mandates that a bill which derogates from the powers of the High Court must be reserved for consideration of the president. Apart from bills which fall within the description set out in the second proviso, the governor may legitimately refer a bill for consideration of the president upon a legitimate doubt about the validity of the laws. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext, so and so. Lord, I'm sorry, I'm always confused with this pronunciation. Excluding it from judicial scrutiny, the court withheld. My Lord, I have read this, my Lord, when I read Hext, my Lord, so I'll not. Yes, I'm not reading it, my Lords. Now, your Lordships, my Lord, kindly come to, my Lord, this point is over, my Lord. My Lord, there are some issues, my Lord, which we have divided with a view to save time, my Lord. My learned friend also would assist your Lordships, would supplement without, my Lord, repeating, my Lord. They would be able to more and effectively assist your Lordships. My Lord, kindly come to 204.
In a louder manner.
Yes, sir.
Both of them.
No, anything remains, no, not survives. Yes, sir.
We'll have to put off the wife.
Yeah, yeah. There was an interesting incident. I'll not share it here. My Lord Justice Narasimha, me and my colleague, my Lord, we went to Pune for arguing one matter, my Lord. Before NGT Pune, my Lord. But I'll some other day, not in the matter. My Lord, question number, page 204.
Why are you unnecessarily thinking about anxiety?
No,
There is another mention.
Either you should have not mentioned.
Now we have
Or
mentioned
if you have mentioned, you mention it fully.
Yes.
Unless it is not embarrassing to my learned brother.
no, but it's not, my Lord, embarrassing to his.
So what happened in NGT Pune?
Lord, I'll just say with his permission.
Not let you proceed.
No, I'll say that.
You
with
can't
his-
stop halfway.
Lord, I'll say that with permission of my learned friend and with an apology. It's not intended to insult. Lord, NGT Pune is a small courtroom. It's like a little slightly bigger bedroom. It's in a government building. My learned friend, all of us were on the same side. He was arguing, Lord, in his own way. Justice Kingaonkar.
In his own volume.
Yes. Justice Kingaonkar was presiding over the bench.
Yes.
So at some stage, he did like this. So my learned friend understood that the honorable judge is unable to cope up with my speed. So he continued the same volume, but reduced the speed. Then I requested my learned friend that the trouble is with the volume, not the speed. And the judge complimented me by saying that, thank you, you prevented Punjab Mail. Sorry, but he's like my brother, my Lord. I can take this liberty. My Lord, page 204. My Lord, this is, my Lord, something very, very serious, and your lordships may take this, my Lord, into consideration. One constitutional organ prescribing time limits for another constitutional organ. Lord, I can, my Lord, I have no quarrel and I will never argue, my Lord, and I'll pitch my argument that statutory functionaries can be bound by a time limit. The deputy collector deciding to grant or withhold non-agricultural permission. But would it apply to constitutional functionaries which are coordinate constitutional functionaries? My Lord, these are the two questions, my Lord, which are question number 5 and question number 7. My Lord, I have incorporated, my Lord, the debate which I have already read. In one line, I may just refresh your lordship's memory. Wherever time limit was stipulated at the time of drafting of the constitution, the time limit was deleted. And in that very provision, wherever time limit was required, time limit is added. So constitutional framers are very conscious of the fact that some functions need a time-bound exercise of power and some functions needs a kind of leeway, and we may not bind the constitutional functionaries with the power. My Lord, please come to page 208, and I'm not going to read this, only for your lordship's assistance at page 209. My Lord, I have compiled the constitutional provisions where constitution itself stipulates the time limit. I'm not reading it. Lord, just Lord, with a view to see that your lordships gets it, Lord, at one place. Lord, 209, Article 22, Article 62, etc., my Lord, the list goes on till at page 224. Wherever the Constitution has thought it appropriate for the object which that particular provision seeks to achieve, the Constitution provides for a time limit. wherever the constitution has, framers have considered. Yes, my lord, kindly note one more thing. Tamil Nadu judgment, which mandatorily stipulate time limits for the Honorable President and the Honorable Governor, relies upon the report of Punchi Commission and Sarkaria Commission. It itself says at the end, and obviously so, that these are our recommendations and we recommend suitable constitutional amendments. Meaning thereby, the reliance on the report itself, my lord, in my respectful submission, may not be correct, because Commission does not say that do it by way of a judicial adjudication. It has to be, my lord, logically. I don't have to stretch this point any further. If a commission is appointed by the central government of the day will consider whether to bring it by way of an amendment or not. But very interestingly, my lord, a converse situation has arisen. My lord, in one judgment, which your lordships would find at page 231, where one organ of the state, namely the legislature, provided for the time limit for another organ of the state, namely the judiciary. And matter went before, my lord, 7 judges bench. And your lordships would find the judgment at page 231.
238.
231.
Paragraph 238.
Lord, I'm sorry, my lord. One fact, my lord, I missed. Lord, there are judgments which I have cited from page 224 to 231, that even in statutes, court cannot add words, supplement words, or delete words. Lord, the leading
Except
judgment.
passes omissus.
Yes, madam. It is conscious omission. And even if the court were to do it, court can suggest that we recommend or we suggest that the competent legislature may exercise its amending power, either constitutional provision or so. But my lord, one judgment, which is, I'm not reading, page 228. 228 is the judgment, my lord, where my lord Justice Narasimha was also, my lord, on the bench. Supriyo versus Union of India. Lord, this is a 5-judge bench, but I found, my lord, that it is not reportable. It has not been reported anywhere, my lords. So this was that right of LGBT community, my lord, my lord, seeking, where, my lord, the court said that we cannot read words into the statute. My lord, this judgment remains unreported. Thereafter, there are 2 judgments which relies upon this judgment, and those 2 judgments, my lord, including electoral bond, they are reported. But this judgment, my lord, remains unreported. As a matter of fact, that's all. Otherwise, my lord, it's a leading landmark judgment, my lord, laying down several issues of seminal constitutional importance, my lord, not only for the country, but for the society. I leave it at that. My lord, page 231.
Yes.
Page 231, my lord. When, my lord, legislature, my lord, provided for timeline for the judiciary. This is where, my lord, we say the separation of powers. Constitutional committee between or amongst 3 or coordinate organs of the state. In P. Ramchandra Rao versus State of Karnataka, that is 7 judges, has been held that time limits for criminal trials cannot be prescribed. Lord, your lordships would see, sometimes facts may justify time limit, but justification does not confer jurisdiction. We may come across a situation where we feel that it is fully justified, that some time limit should be done. But if there is no jurisdiction, there is no jurisdiction. justification can never confer jurisdiction. Well, let's see, kindly see, my lord, what the 7-judge bench is pleased to observe. When one organ fixes time limit for the other, my lord, incidentally here, it's a converse. Legislature fixing it for the judiciary. Para 225, my lord, of this judgment I have quoted. During the course of its judgment, also the Constitution bench made certain observations which need to be extracted and reproduced. But then speedy trial or other expressions conveying the said concept are necessarily relative in nature. Kindly pause here for a minute. There are several considerations: lack of staff, lack of my lord, the burden of cases,
Depending
several
on the case.
considerations.
Depending on case to case, like.
Case to case, some case may take longer, some
Bomb
case
blast case, there might be 200, 300 witnesses.
witnesses. Lord, that is the justification. Lord, why I am pausing here? Lord, in case of decisions of the nature which governor or the president takes, they are polycentric decisions. They are not ticking the boxes that yes, complied with, complied with, complied with. There are they may decide, they may choose to call the governor, choose to call the chief minister. They may take some other consultative process to ensure that there is no impasse, etc., etc. And therefore, there may be several reasons for the delay. One may ask, speedy means how speedy? How long a delay is too long? We do not think it possible to lay down any time schedule for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in the particular court, means of communication, and several other circumstances have to be kept in mind. It is neither advisable nor feasible to draw or prescribe an outer time limit for conclusion of all criminal proceedings. It is not necessary to do so for effectuating the right to speedy trial. We are also not satisfied that without such an outer limit, the right becomes illusory. Even apart from Article 21, courts in this country have been cognizant of undue delay in criminal matters, and whenever there were inordinate delay or whether proceedings were pending, where the proceedings were pending for too long and any further proceedings were deemed to be oppressive and unwarranted, they were put an end by making appropriate orders, prescribing periods of limitation at the end of which the trial would be obliged to terminate the proceedings and necessarily acquit or discharge the accused, and further making such directions applicable to all the cases in the present and for future amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts, however liberally we may interpret Article 32, 21, 141 and 142 of the Constitution. The dividing line is fine but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon the field of legislation properly meant for legislature. Binding decisions can be issued for enforcing the law, and appropriate directions may issue, including laying down of timelines or chalking out a calendar for proceedings to follow to redeem the injustice done or for taking care of rights violated in a given case or set of cases, depending on facts brought to the notice of the court. Now, my lord, this court says this, my lord, which generally it reserves its own my lord, domain. This is permissible for the judiciary to do. Legislature cannot. But it may not, like the legislature, enact a provision akin to or on the lines of chapter so-and-so of the Code of Criminal Procedure. So legislature cannot. My lord, here also, I think, my lord, the provision was deemed acquittal or something. My lord, it was judgment of the Supreme Court which put time limits. on completion of the trials. And the my lord, recently in Allahabad High Court, my lord, judgment also, my lord, where the my lord, that Asian resurfacing judgment that it will have to be decided within 6 months or interim order will be deemed to have been vacated.
That is reviewed.
Yes.
That is recalled.
That recalled by a 5-judge bench. Five-judge bench. Lord, here the judgment said judiciary's power is untrammeled, Lord, as per all the judgments, that if it is not decided within 6 months, the interim order is deemed to have been vacated. We are also dealing with, my lord, similar situation where it is deemed assent, etc. My lord, I'll come to that.
Outer limit at all. Your question is, isn't there an outer limit? Can the constitutional interpretation be left to a vacuum? Creation of a vacuum, a long jump.
My lord, there are two answers.
Jump by. Of course, we have had that there's nothing like a pocket veto. Just keep it and don't respond. That's not permissible. But though we can't specify a time limit. But at the same time, there must be some way in which the process works out. Can it be a situation where not acting on a bill which is sent to the governor
No, that is,
itself is a full stop, no further, is it?
Lord, I'll answer it.
Where we need your assistance.
Yes, my lord. I'll answer, my lord, in two ways. A, what your lordships very rightly, my lord, feels pained at is a justification for fixing time limit, but will not confer jurisdiction to fix time limits. Number two, if that is so, Lord, we are not flooded with cases where, my lord, such situations have arisen. Lord, there are instances where, Lord, 1 or 2 states have come, my lord, with such situations. If that is the problem, and that may be the problem, the remedy lies with the constitutional framers, my lord, with the parliament. The parliament will have to be done. Your lordships have said time and again in several judgments that in view of this, we request the parliament. Your lordships never direct. Your lordships never direct, coordinate constitutional functionary. Even if the notice goes to a constitutional functionary, your lordship's registry's form is also different. You are called upon to remain present is not there. You are requested to put your appearance because that's the constitutional committee. Lord, your lordships have said in large number of cases that the desirability of the parliament to consider this. But the practical answer, my lord, if I were to, my lord, assist your lordships, is the political answer. Suppose a particular governor is, my lord, sitting over the bill, my lord, there are political solutions. And such solutions are taking place, and my lord, it is not everywhere that state is advised to rush to the Supreme Court. Lord, the chief minister goes and requests the prime minister. Chief minister goes and meets the president. There are delegations which go that this is the bill which is pending. Please talk to the governor. Let him take decision one way or the other. Telephonically, they are sorted out. There is a joint meeting with prime minister, chief minister, and the governor, or the president, chief minister, and the governor. And such impasse is not solved. Lord, that would not confer jurisdiction to lay down a guideline by a judgment. That is the question. That in absence of a constitutionally provided guideline, time limit, can it be read even if there is a justification? And my lord, genuinely, my lord, I'm urging your lordships to consider such issues are arising in every state since last many decades. I'm not talking of this government or that government, but the statesmanship, the political maturity, the political statesmanship, they are at play. They meet the constitutional functionaries at the center. They discuss, debate, because all bills are not contentious bills. They are kept, my lord, for one reason or the other. There is some impasse, some lack of communication. Some clarification might be required, which might be wanting. Then, my lord, they come together and a political solution is found that, all right, if you don't want to do it, refer it to the president will examine. Lord, these are the solutions of the problem. Lord, I'm therefore, my lord, at the cost of making a little unpleasant argument, my lord, saying that every problem in this country may not have solutions, my lord, here. There are problems, my lord, in the country where you must find solutions within the system. This is what your lordships have said in this judgment, that there is a question of delay. Article 21 is affected. People are languishing in jail. But solution will have to be found from within the system. And your lordships are doing a lot from within the system for streamlining, for ensuring that timely trials take place with assistance of the legislature. Now we have, my lord, the legislative provisions that even summons can be served through electronic mode. Even a WhatsApp message is a good service of summons. How responsibilities are fixed for the officers to bring in witnesses, etc. But this is a collaborative exercise. Lord, suppose, my lord, there is a bill passed by the parliament. Kindly, my lord, suppose there is a bill passed by the parliament that people of the country are approaching us that my trial is pending since 30 years, my son is in jail, and it is not being taken up. I am posing a question to myself, my lord, can the executive, maybe the president of India, say that no, I understand there is a problem, and therefore your trial is treated to have been terminated. You are deemed to have been acquitted. You have already undergone 30 years. It cannot be done. Justification can never confer jurisdiction. And this separation of power, what I am saying without mincing words, must be a two-way street. Lord, I'll just show your lordships, Lord, Allahabad judgment, where there was again a judicial verdict, where within 6 weeks, if it is not done, 6 months, then it is vacated. Then, my lord, this court, my lord, speaking through 5 judges bench, set aside that no time limit can be prescribed. Now, please come to another judgment, which is again a landmark judgment, my lord.
Mr. Solicitor, that against the inaction of the governor in a particular given field. It can vary from state to state, it can vary from action to action, or inaction to inaction.
My apologies.
In a particular case of inaction, if the aggrieved state or its functionaries, if they approach the court, the power of judicial review according to you is completely barred.
Look, right now, I am on the point, I am not on justiciability or judicial review. I am on the point that by a judgment, the court cannot fix time limit. That you do it within 3 months.
All right, you will expand this argument and then will also enlighten then what kind of the
Remedy is available to
remedy
the
the
person.
courts would.
Therefore, my lord, I answered,
If there is a wrong, then there has to be a remedy.
ubi just ibi remedium, my lord, I understand. But there are, my lord, problems which all problems in the country may not be this forum to be the only solution. There are solutions, my lord, within the system, and people are finding out those
No,
solutions.
no, as the custodians of the Constitution, this court is a custodian of the Constitution.
My lord, each organ is, my lord. Each organ is in their own respective fields, my lord.
Suppose if a constitutional functionary, which is entrusted with certain function, refuses to discharge those functions without any valid reasons, whether the hands of the constitutional court would be tied and say that no, we are powerless.
It's not, my lord, an
Power of
argument of,
interpretation only the Supreme Court has of the
Lord,
Constitution.
no, that is the feeling, my lord, that all problems.
Interpretation of the Constitution.
Interpretation, yes. Yes, sir.
Court has.
Interpretation, yes, my lord, but not legislation.
No,
Now
not
there is a problem, you do it in 3 months. Kindly see, my lord, the way, my lord,
For that, cannot we go to the constitutional debates? Find out what was the intention of the Constituent Assembly behind enacting such provisions. Can't we do that?
no, your lordships can consider, my lord, whichever way, my lord. My argument is this, my lord, that time limit cannot be stipulated.
if the power of interpretation of the Constitution, if the power of interpretation of the Constitution rests in the Supreme Court, then rules of interpretation of law are to be tried by the court.
My lord, then, my lord, my answer is one answer.
Action.
Justiciability is something else. Adding words or amending the constitution itself, your lordships have said even statute cannot be amended by judgment, is something else. Generally, and this is my answer, my lord,
We have to go on the first principle, literal interpretation.
basically, my lord, what a tap on the back jurisdiction, my lord, as we understand. You can always say that just look into it. You can call the law officer, just look into it and see that it is done, and it is generally done, my lord. But please see, my lord, the directions. My lord, I would respectfully urge your lordships to see that.
We agree. That if extreme view is taken, is no justification to argue that you can't therefore take any view at all. We are not at the two extremes of prescribing time limits now here within 1 week or so, or on the alternative, don't have a power at all to do it.
My lord,
There must
I'm
be a
coming,
way by which you make the constitution work,
my lord,
process work.
flexibility has to be there. The system must work smoothly.
No, there is no doubt that you must have free play in the joints.
My lord, kindly see the
But,
direction for my satisfaction.
Yes, that is,
My lord, page 12569, volume 31, volume 31, my lord, Roman 531.
they begin at 12569.
No, no, the relevant part, the directions, my lord, where in our submission, my lord, this amounts to amending the para, my lord, is Roman 14 of the conclusions.
Yes.
These are, I'm reading the conclusions.
12569 to 1259.
12569. Your lordship said, my lord, it starts with timelines. My lord, kindly come to 12568 first. What is this, my lord? Your lordships would, and with profound respect, my lord, every judgment deserves the respect, my lord, and maybe there may be a justification for doing this, but my argument is justification do not confer jurisdiction. My lord, 14, keeping in mind the constitutional significance. Your lordship gets, my lord?
Yes.
My lord Justice Narasimha gets. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction of the governor subject to judicial review by the courts. In case of either withholding of assent or reservation of the bill for consideration of the President, upon aid and advice of the State Council of Ministers, the governor is expected to take such action forthwith, subject to a maximum period of 1 month. In case of withholding of assent contrary to the advice,
In case of either withholding of assent or reservation of the bill for consideration of the president, upon the aid and advice of the president,
then 1 month.
the government is expected to take such action forthwith. What action?
Either withholding, assenting, or reserving, etc. But the governor may choose that I'll call the chief minister. We will have debate, discussions, persuasions. What is the problem I am facing? You are, if you can again go back to your cabinet and sort out the situation, nothing. Then, my lord, 2. In case of withholding of assent, contrary to the advice of the State Council of Ministers, the governor must return the bill together with a message within a maximum period of 3 months. In a case of reservation of bills for the consideration of the President, Contrary to, contrary to the advice of the State Council of Ministers, the governor shall make such reservation within a maximum period of 3 months. In case of presentation of a bill after reconsideration in accordance with the first proviso, the governor must grant assent forthwith, subject to a maximum period of 1 month. Lord, this, my lord, is, and my lord, thereafter the says that a president will, my lord, there are two things. And my lord, I'll try to be as modest as possible in placing this. And I'll come to that, my lords. It's a separate chapter, but let me at this stage say, the second direction given is, my lord, that president and governor will record reasons. And if they do not follow these guidelines, this timeline, states can come to the High Court, go to the High Court or come to us. Meaning thereby, this Honorable Court, one institution of the three coordinate branches, is directing the Honorable President of India that you decide within 3 months, you better give reasons, and you, the state, if she doesn't decide, file a petition in 226 or come here under 32. This is, my lord, the direction. I respect the directions, my lord. There may be justification, but justification cannot confer jurisdiction.
Clear cutoffs, the cutoffs.
Yes.
Have amended the constitution.
No, this, Pavitra is in ignorance of Samsher Singh.
No, Tamil Nadu judgment.
No,
No, Pavitra
according to
is
Tamil
saying
Nadu
that-
judgment, Pavitra which says that there
It's per
can't
incurium.
per incurium Samsher Singh.
No, yes, which it is not. My lord, I'll show that paragraph.
Para 56.
We are just wondering because it's 12:10, so whether the learned solicitor would be asking for a compound break.
No. Yes. I am generally comfortable till 1 o'clock. That word is coined during Corona. Comfort break, my lord. That's a good word, my lord.
Even in the conferences now they use that word,
Yes.
comfort break for 15 minutes.
Sense of humor is always welcome in this court. The sense of humor is always welcome in this court.
Yes. Otherwise, my lord, the proceedings are generally boring,
Boring, monotonous.
monotonous, boring. The subject is also boring, and
The subject is
The subject is not boring. Yes.
not at all.
no, subjects means the law as a subject, not this subject. You need not oppose me everywhere. I'm not saying this subject is boring. Generally, law as a subject is not a very interesting subject, my
I
lord,
don't
for
agree at all. It's
others.
the most interesting subject, Mullah.
My learned friend is
I have to be a
Kamath.
Kamath.
He is Mr. Kamath, my lord. He is Mr. Kamath, my lord. He opposes everything I say.
Hari Vishnu Kamath.
Yes. No, now on the timeline, no, there is a direct judgment of the 5-judge bench. Lord, kindly come to page 233.
230.
233.
Your notes.
Yes, my written submissions. 233. Article 200 was considered from the point of view of timeline. And timeline was not prescribed. Lordships may kindly keep one thing in mind. Article 200 follows with Article 201. Obviously, in Article 201, timeline is stipulated. If the President returns the bill to the Legislative Assembly within 6 months.
6 months.
Wherever, my lord, I have not read the list and I don't intend to, but all provisions where it was necessary that timeline has to be prescribed, it is so prescribed by the Constitution. The only question is, can it be done by a judgment even if there is a justification in a particular case? Maybe the court may be confronted with some extraordinary fact situation and feel that this is something extraordinary. Then the remedy will not again, my lord, be the judicial remedy. Now, please have a look at, my lord, page 233, 5-judge bench judgment of Purushottam Nambudri versus State of Kerala, para 15. So this was a case where a bill would lapse because of non-prescription of the time limit, because one assembly may pass a bill, present it to the governor, and thereafter, my lord, the assembly's tenure is over. Or assembly resigns, new assembly is formed, etc. My lord, kindly see para 15. Your lordships have para 15. It is clear that if a bill pending the assent of the governor or the president is held to lapse on dissolution of the assembly, it is not unlikely that a fair number of bills which may have been passed by the assembly, say during the last 6 months of its existence, may be exposed to the risk of lapse consequent on the dissolution of the assembly, unless assent is either withheld or granted before the date of the dissolution. If we look at the relevant provisions of Article 200 and 201 from this point of view, it would be significant that neither article provides for a time limit within which the governor or the president should come to a decision on the bill referred to him for his assent. Where it appeared necessary and expedient to prescribe a time limit, the Constitution has made appropriate provisions in that behalf. Vide article so-and-so, so-and-so, so-and-so. My lord, the court cites only 3 examples, but in my list, I have given at least 30 examples.
More than 2 dozen, yes.
Where time is prescribed wherever it is so felt necessary. In fact, the proviso to Article 201 requires that the House to which the bill is remitted with a message from the President shall reconsider it accordingly within a period of 6 months from the date of receipt of such message. Therefore, the failure to make any provision as to the time within which the governor or the president should reach a decision may suggest that the constitutional makers knew that a bill which was pending the assent of the governor or the president did not stand the risk of lapse on the dissolution of the assembly. That is why no time limit was prescribed by Article 200 and 201. My lord, kindly as you visualize a situation where the outgoing assembly passes a bill, places before the governor. The new government is formed, maybe of a different political party. The new council of ministers can give advice to the governor to withhold that bill, that it was passed by the earlier assembly. Now the new assembly is formed. We would like to have debate on that. The outgoing cabinet also may say that now our tenure is over. You grant assent to the bill. Now, in view of the judgment, you have to do it within 1 month. The governor may choose that now this is outgoing ministry. Let me wait till the fresh election takes place. Maybe the fresh mandate of the electorate returns somebody else, and they will apply their mind. Outgoing people who have lost their time of electoral mandate may not impose their decision on the incoming. So, my lord, these are all polycentric circumstances which governor, my lord, as constitutional framers, my lord, envisage as a friend, philosopher, guide, as a person who is there as a central representative to ensure that everything functions smoothly. There are several considerations which weigh.
Question in Purushottam Nambudiri, was it considering an issue of lapse of a bill?
It was a lapsing.
Was it considering delays?
Lapse.
That's a bill on the event of dissolution of the
It won't
assembly.
lapse. Therefore, they have answered the question that it won't lapse.
No, they've answered the question.
Correlative, but you are saying,
My lord, fight.
considering that it won't lapse, one should assume.
But then these observations on a two bench.
The five-judge bench observation, my lord, that
The two judges ought to have considered this.
Lord,
Was it cited before that?
wherever, my lord, it not only confines to the lapsing or not lapsing. It says that time limit cannot be prescribed for wherever it is necessary, it is so prescribed, and give examples. And whenever it is not prescribed, it is consciously not prescribed. Therefore, we cannot do it.
Was it cited before the learned?
Yes, my lord, and it is dealt with at page para 235. I'll just, my lord, show that.
Doesn't apply at all.
35 of your or the,
It says, my lord, that it was in the context of lapsing.
Page number?
Para
Para 235 of the judgment.
12379.
Huh? Yeah.
My lord, the learned judges, my lord, is pleased to quote Nambudri
1, 2,
12379 at 12379.
Paragraph 236.
236.
232 से start हो गया. Yes.
Yes, my lord. This para is quoted. It was cited, my lord. And please, my lord, bear in mind that Nambudri is a 5-judge bench.
This not. Yes, sir. Absolutely nothing to do with this matter.
So, para 236 may I read, my lords.
Forget 236, read the judgment.
Lord, can I show, my lord, the facts of Nambudri first, my lord, if your lordships would like to see. My lord Justice Narasimha, my lord, 1186 is the page number, my lord, of volume 3. Volume
5.3.
5.3 at page 1186. Lord, even if the context was lapsing, what I read is the ratio.
Ratio.
Five-judge bench says
That
that
wherever the wherever the assembly required timelines to be provided,
they have
they
provided.
have provided,
And therefore, we cannot provide for a timeline. The prayer was this, that you provide for a timeline, otherwise it would lapse.
That's interesting.
Was pending before the president, and if this assembly would dissolve.
Yeah, they say wherever it is. First, I am reading, my lord, 1186, my lord, which is Nambudri, the facts of Nambudri.
Broadly stated.
356 order in this.
Lord,
Yes.
my lord, the Chief Justice says 1186, the facts of Nambudri. Just above 1186, my lord, para 2.
Starts from 1185, yes.
The
Kerala-
Kerala Agrarian Relations Bill.
Yes.
Lordship gets, my lord.
Yes.
The Kerala Agrarian Relations Bill, which has ultimately become the Act, was published in the Government Gazette of Kerala on December 18, 1957, and was introduced in Kerala Legislative Assembly on December 21, 1957, by the communist government, which was then in power. The bill was discussed in the Assembly and was ultimately passed by it on June 10, 1959. It was then reserved by the governor of the state for the assent of the president under Article 200 of the Constitution. Meanwhile, on July 31, 1959, within less than a month, more than a month, the president issued a proclamation under Article 356 and the assembly was dissolved. In February 1960, midterm general elections took place in Kerala, and as a result, a coalition government came into power. On July 27, 1960, the president for whose assent the bill was pending sent it back with his message requesting the Legislative Assembly to reconsider the bill in light of the specific amendments suggested by him. On August 2, 1960, the governor returned the bill remitted by the president with his message and the amendments suggested by him to the new assembly for consideration. On September 26, the amendment suggested by the president was taken up for consideration by the assembly, and ultimately on October 15, 1960, the bill as amended in light of the president's recommendation was passed by the assembly. It then received the assent of the president on January 21, 1961, and after this thus became law. This was the facts, and the issue was whether the bill would lapse or not, my lord. Now your lordships may kindly come to para 14.
14.
My lord, which is at page 1193. Your lordship gets, my lord. 1193, my lord, gets, my lord. Para 14.
yes,
In this connection, it is necessary to consider Article 200 and 201, which deal with bills reserved for the assent of the governor or the president. Article 200 provides inter alia that when a bill has been passed by the Legislative Assembly of a state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for consideration of the president. The proviso, my lord, it's paraphrasing the proviso, my lord.
you had already read para 15 to us.
Para 15.
Either you or the learned attorney, either of you.
No, my lord, I read just now. I just now read, my lord.
Earlier it was.
Just now I read, my lord, that court said that no, we cannot read into any timeline. My lord, why the court is seeking 197(1)(b? Please have a look at 197(1)(b). This para 15 reads 197. Restriction on power of Legislative Council as to bills other than money bill, where there is a time limit stipulated. This question was considered. It is a ratio, not a passing reference. This is a statement of law. My lord, the provide. It's again paraphrasing.
They should read
My
190.
lord, it refers to 197, para 14 and 15 both refers to 197, and 197 provides for a bill, for a time limit for a bill.
Read 196.
So under 197, there are specific timelines.
Yes. And 200 does not have. So virtually the prayer was that you read some timeline in 200.
And the argument was that the bill had lapsed.
Yes.
That was rejected.
Yes. Article 196, sub-article 5. And the Supreme Court says it doesn't lapse because there is no timeline. And whenever timeline was required, it is stipulated.
That was the question.
That was.
That's right. That's
So
right.
it is my lord, a statement of law. It's not a passing observation of a constitution bench. Well, that is why, my lord, the constitution bench gives the dates also. Time was the issue, my lord, that whether it should have been done within particular time limit. Now, my lord, again, my lord, B.K. Pavitra, I have read, my lord, I'll not repeat that, my lords. Now, my lord, the court Lord, relies upon
Interpreting two-
3 judgments, my lord, for fixing the time limit. I'm sorry, this Kesham judgment, my lord, that is the Manipur Assembly Speaker. No, I don't wish to, my lord.
No, no, Kesham, I have already distinguished.
Lord, it was a tribunal.
No, no, because all the constitution benches have held that speaker, while acting under para 6, acts as a tribunal and therefore is amenable to the jurisdiction of the High Court under Article 226, 227 and this code under 136. And while discharging those functions, it does not enjoy the constitutional immunity under 112 and 212.
Yeah, that Raja Rampal judgment 212, etc., will not apply because he is a tribunal. And therefore,
It's a tribunal and right from Kyoto, it has been consistently held
yes,
that he doesn't enjoy the constitutional immunity.
immunity under the
Under-
privileges, etc.
112 is so far as speaker and chairman and
212 for
so
assembly.
far as the state legislatures are concerned.
Yes. So it is, my lord, that can never be a justification for prescribing guideline for a constitutional functionary
And
exercising.
Kesham also does not lay down guidelines in general.
It's only for 10th schedule.
No. It says in the facts of the case.
Yes, it doesn't bind other things.
Because an argument was made
It was paid.
like the UP case. The court itself should exercise the power and declare them to be disqualified because the disqualifier was apparent.
Mayawati judgment, my lord. where
Mayawati, Raja
It was, my lord, Yadav, Rajendra Singh Rana.
Rajendra Singh Rana was
There, my lord, it was Mulayam Singh Yadav versus Mayawati. Court said that now
Maya-
2 months have left.
from Mayawati's party, the 13 MLAs that defected to
Correct, correct.
Mulayam Singh.
Mulayam Singh
They
Yadav,
had given a letter that Mulayam Singh should be made the chief minister.
minister,
And-
that was
and-
treated.
And this court held that the very fact that the MLAs elected from BSP wrote a letter that
Other leader should be.
the leader of the SP should be made a chief minister. Itself was sufficient enough to disqualify them. And
That's correct.
On the ground that they
passed an order of disqualification directly in the Supreme
here.
Court.
And they said, but the Honorable Court said in Rajendra Singh Rana that they're writing a letter requesting the president to invite the other party's leader amounts to their voluntarily giving up membership of their original political party. Now 2 months of the assembly session has left and therefore there is no point in returning the matter to the speaker and therefore we decide it here and declare them disqualified. But that is again, my lord, a speaker is a tribunal. My lord, that in my respectful submission, my lord, I may not labor much. My lord,
So that has been followed in Nebam Rebia and
Nebam Rebia.
Subhash Desai.
Yes.
But I've been making this argument for 5 years that it's a tribunal, Mullahs, and every time the resistance was, but he's a speaker. Luckily, Mullahs, we have your lordship's judgment, Mullahs. But for 5 years, I've been saying that.
Constitution,
I know,
Which
but
benches
Mullahs,
also-
for 5 years, we've been saying because speakers were not deciding issues. And
And,
for years, they were not deciding. And I was saying they are tribunals, but for 5 years, Mullahs, nobody accepted that position because the other side would say he's a speaker. Then your lordships decided the matter, and we are so happy that you did, Mullahs. At least that put a quieter.
we are held that we don't want to create a situation of operation successful and patient dead. Then we have said that we don't want to create a situation that operation successful and patient dead.
Lord, kindly come to page 238. Lord, interpretation of as soon as possible. Lord, your lordships have seen two things. In Article 200, main part, no time limit. Article 200 main part does not prescribe time limit. The proviso says as soon as possible. In this context, I'm just giving one judgment on as soon as possible. Please come to page 238. Lord, this was a case of preventive detention and therefore directly Article 21 was involved. Article 21 and Article 22, personal liberty, fundamental rights. Abdullah Kunhi versus Union of India. In Francis so-and-so,
Which page have you cited?
Lord, I'm sorry, 238. 238.
There are 253.
Yes, my Lord, at the foot, para 14. In Francis Corel Mullin versus WC so-and-so, Justice Chinnappa Reddy, while dealing with the time imperative for consideration of representation, has emphasized, we, however, hasten to add that the time imperative can never be absolute or obsessive. The court's observations are not to be so understood. There has to be leeway depending on the necessities. We refrain from using the word circumstances of the case. One may well imagine a case where a detainee does not make a representation. Then it is various situations concerning detainee. I have given the situations with the governor may say. Ultimately, my lord, the bold line. But allowance must surely be made for the necessary consultation where legal intricacies and factual ramifications are involved. Lord, here in this case, political considerations, politics not, my lord, in the derogative sense of the term. There can be, my lord, a political statesmanship which is at play. There may be a good reason for him to let the situation calm down. It might be, my lord, having some impact on the national policy. He might be in consultation with the President of India. There can be several. These are all polycentric decisions. These are not A versus B, whether A is right or B is right. It has consequences. It has fallouts. It has social implications. It has economic implications. It has implications outside the state. My lord, similar is the case. My lord, in Joglekar, I'm not reading it. It's the same, my lord, ratio. Then in 240, my lord, I'm not reading it, my lord. My lord, the court's reliance on Sarkaria Commission and Justice Punchi Commission, my lord, is wrong because they also say that ultimately these are our recommendations, which the government which appointed them did not accept. But that apart, they also recommended that accordingly amend the constitution. They also did not even remotely suggest that the court can do that. Then, my lord, manner of exercise of power, my lord, which is at page 242. My lord, I'm not taking your lordship's much time because I would earnestly request my learned senior friend, my lord, to deal with that. My lord, question is this, my lord, can the manner of exercise of the power be prescribed by the court that you will give reasons when there is a judgment, my lord, where there are some observations that some reasons are necessary. I'm not going into it because this is not a list. I'm just seeking the advice of your lordships whether a judgment can say that. My lord, I have, my lord, earmark page 245, para 272. I'll read only one para.
One minute.
But show us that portion of the two-judge bench judgment where reasons
Yeah,
are
yeah,
directed.
yes. This is the same.
That may be valid for when some member of the executive exercises administrative powers,
Statutory powers, my lord, we can,
wherein some order inviting adverse civil consequences to a party is
correct. My lord, for example, the deputy collector deciding whether to grant
license or not.
license, grant non-agricultural land use permission or not, etc., etc. My lord, I don't think, my lord, we can reduce constitutional functionaries of coordinate benches, my lord, to this. My lord, I'll just find, my lord, show, my lord, the directions. Lordship, only give me a minute. No, we are just trying to find out. Yeah. No, my lord, I just will not find out. We are unable to immediately lay our hands, but your lordships can take it.
There are directions that the
There are directions that
government should
president,
record it.
president and governor both would decide in a particular time frame. Second direction, both would give reasons. And third, in case of non-compliance, the state can approach the High Court and the Supreme Court. These are the three directions.
The Contempt of Court Act.
No, my lord,
For
third.
seeking advice.
No, that is something, that is third.
So that will be in case of violation of timeline.
In case of violation of timelines, we can come for a mandamus that the High Court will direct the President of India that you have violated.
Issued why the fresh mandamus is required. Timeline
Now,
is fixed.
now,
General mandamus.
It may be a contempt action, my lord. there.
mandamus is issued, which is binding to everyone within the territory of India under 141.
It is 141. Lord, please come to page 245 of my my lord, submissions. Why, my lord? The nature of exercise, the manner of exercise of powers by coordinate constitutional functionaries. Lord, it may not be a good comparison, but suppose, my lord, the parliament or the executive were to say that courts should not give 600-page judgments. It's manner of exercise of power. Maybe they are just, maybe in some cases it may be required, but justification does not confer jurisdiction. That's my lord, fundamental point. That write a judgment, not a thesis, my lord. Sometimes, my lord, this is my word, not Honorable President's, my lord, view. It should not be an article to be published in some law review. It should be a judgment deciding the list between the parties. Lord, please come to page 245. Para 272. It is also vital to state here that for functions of the governor, the Constitution itself prescribes conditions for the exercise of power. Illustrations of such functions are enumerated below. Article 192, subarticle 2 provides that before giving any decision on the question of disqualification of a member of the House of Legislature, the governor has to obtain the opinion of the Election Commission. Constitutional mandate, this is how you will exercise your power. Functions under Article 233, 234 have to be exercised in consultation with the High Court. Manner of exercise of power stipulated by the Constitution. The governor has to exercise functions under Article 160, that is contingency function, in accordance with the provisions made by the President in that behalf. Again, manner of exercise of power. The power under Article 187(3) has to be exercised in consultation with the Speaker of the House. Under Article 2083, the governor makes rules of procedure as to the procedure with respect to communication between two houses after consultation with the Speaker of the Legislative Assembly and Chairman of the Legislative Council. Again, manner of the exercise of power by the governor controlled by the Constitution. Power under Article 258A has to be exercised with the consent of the Government of India. Article 316, 318, which deal with appointment, condition of service and removal of chairman and members of State Public Service Commission, also stipulate certain conditions how he would exercise those powers. My lord, in fifth schedule also, my lord, I have not added this, my lord, but there is a tribal advisory council and he has to consult them. So, my lord, wherever the manner of exercise of power is to be circumscribed or to be stipulated, the Constitution stipulates. It, in my respectful submission, cannot be added by way of a judicial pronouncement. So that is, my lord, and there are other judgments, my lord, which I have cited. Now, my lord, I come to another important fresh question, whether the exercise of power of the president, either under Article 111, that is grant the power to grant assent, and that of the governor under Article 200 and the president under 201, justiciable. Lord, there is a difference between power of judicial review and justiciability. And in my mission, Lord, the view that it is not justiciable is supported by, Lord, more than one judgments, my lord, few of which are constitutional bench judgments, that these powers are not justiciable. Kindly bear in mind, all judgments have said that the power of assent, Lord, the title of Article 200 is power of assent, is a legislative act because the governor is a part of the legislature. And otherwise also as a coordinate constitutional organ, the power is not justiciable. That is the law. Lord, if I can come, invite your lordship's attention to page 248. Lord, when we say, Lord, my lord, and kindly take this as a constitutional argument. In Britain, the concept is parliamentary supremacy. The courts cannot go into the validity of the law also. India, fortunately,
Except with human rights,
yes, with human, because of one particular act.
particular act.
That
That too only the Supreme Court.
only the Supreme Court, not other
Not the High Court.
and only on the ground of it not being compatible, incompatible.
Only with regard to their human right.
Yes,
They
human-
can't set aside legislation like the High Court in the India can do.
It is only a declaration, my lord. Even the legislation continues. My lord, that's the situation. But fortunately, my lord, your lordships, therefore, my lord, I always say that Supreme Court of India is the most powerful court in the world. Your lordships can set aside the parliamentary legislation, state legislation, any act, etc., constitutional amendment also, complete. But this is a legislative act, and it is act or a function of a coordinate constitution organ. Now, my lord, in this context, my lord, I have divided, my lord, this is a major point, my lord. The rest of the points now, remaining points would be minor, but this would be a major point. Please come to page 248. My lord, we do not, I was just saying, my lord, that Britain has parliamentary supremacy. We have constitutional
Constitutional
supremacy. We do not have judicial supremacy also. Parliament supremacy also. Nobody is supreme. All are sovereign in their respective fields. And in that background, the question,
Sovereign is the Constitution.
sovereign is the constitution,
All three organs work under the spheres allotted to them by
to
the
them under the constitution, and they are sovereign in their respective fields. But supreme is the constitution, unlike, my lord, parliamentary supremacy, which is accepted in Britain. Now, my lord, I have divided this, my lord, in these my lord, points. Para 276. The nature of power and its justiciability. Your Lordship gets on page 248.
Governor and president.
Governor and President. Now, President has two powers, 111 and 201, and Governor has 200. While exercising justiciability of exercise of power by the President and the Honorable Governor under so-and-so, the submission is divided in the following categories. The nature of power and its justiciability, non-justiciability as a facet of independence of three coordinate organs under the Constitution. All the three organs have certain core functions or plenary powers which are reserved exclusively for each of the organ. But for example, Article 356 is the power of the governor, but it is justiciable. But there are certain functions which are core constitutional functions, my lord. And I will elaborate, my lord, and explain how, my lord, I distinguish them. Then judicial restraint and consistent view of this honorable court against judicial legislation, even when judicial review is undisputed, justiciability is variable. Even if your lordships have the power of judicial review, its justiciability would vary. Your lordships may still say that I have the power of judicial review, but for ABCD reasons, I will treat this to be non-justiciable. National security, etc., my lord, foreign policy, etc. One organ of the state under
Do that, my lord.
Yes, Mr. Subramanian has been sitting, but we have done many constitution benches together, Mr. Sibal and me. Therefore, this is what I must admit, I have learned this, my lord, that this is a tradition which must be followed.
I'm obliged.
Except the comfort break.
Partly, my lord. Yes.
My lord, please see. Now, my lord, kindly come to my lord, haste I have read, my lord. So I will not read it, my lord. But no, I have not read, my lord, this hoist or haste, my lord, whatever. This paragraph, my lord, I have not read. I am on the
Go is silent, so next time you won't have problem here.
haste, yes, my lord, haste. Haste. Lord, why classical concept of judicial review will not apply, my lord, even if there is a judicial review, because of justiciability, because of the very nature of the function, my lord. And in that, my lord, haste pharmaceuticals, para 84, which I did not read because I read it for a different purpose, different point. Para 84, my lord, Justice Nassima would get it 250. Page 250 of my written submissions. Lord, this is a judgment of three honorable judges. And your lordships may kindly bear in mind the title of 200 is Assent of the Governor. So it encompasses all options which are available with the governor. There was quite some discussion at the bar as to whether the assent of the president is justiciable. It was submitted that since not only subsection 1 of section 5 of the Act, which provides for the levy of surcharge on dealers having a gross turnover of rupees 5 lakh in a year, but also subsection 3 thereof, which interdicts that no such dealer shall be entitled to recover the amount of surcharge collected from him, are both relatable to entry 54 of list 2 of the 7th. There was no occasion for the governor to have referred the bill under Article 200 to the president for his assent. The challenge was that his act of referring the bill to president is unconstitutional. It is somewhat strange that this argument should be advanced for the first time after a lapse of 30 years of the inauguration of the Constitution. Immediate provocation for this argument appears to be an obiter dictum of Lord Diplock while delivering the judgment of so-and-so that the courts are not powerless when there is a failure to exercise the power of revocation of a proclamation of emergency issued by the ruler of Malaysia under section so-and-so of Internal Security Act. The ultimate decision of the Privy Council was that since by virtue of section 47(2) of that act, the security area proclamation remained lawful until revoked by resolution of both houses of parliament or by the ruler, it could not be deemed to lapse because the condition upon which the ruler had exercised the discretion to make the proclamation was no longer in existence. That being so, the decision in Te Cheng Po case is not an authority. Lord, this is now Honorable Supreme Court, my Lord, says in haste. That being so, the decision of Te Cheng Po is not an authority for the proposition that the assent of the president is justiciable, nor can it be spelled out that the court can inquire into the reasons why the bill was reserved by the governor under Article 200 for the assent of the president, nor whether the president applied his mind to the question whether there was repugnancy between the bill reserved for his consideration and received his assent under Article 254(2). There is no provision in the Constitution which lays down that a bill which has been assented to by the president would be ineffective as an act if there was no compelling necessity for the governor to reserve it for the assent of the president. A bill which attracts Article 254(2) or Article 304(b), where it is introduced or moved in the legislative assembly of a state without the previous sanction of the president, or which attracted Article 31(3) as it was then in force, or falling under the second proviso to Article 200, has necessarily to be reserved for the consideration of the president. There may also be a bill passed by the state legislature where there may be a genuine doubt about the applicability of provisions of the Constitution which require the assent of the president to be given to it in order that it may effectively be an act. The governor is confused whether there is repugnancy or not, but he errs on the safer side that there may be a repugnancy and refers. There may also be bill passed, any provisions with so and so. I'm sorry, Mullah. Even if it is ultimately turns out that there was no necessity for the governor to have reserved a bill for the consideration of the president, still he having done so and obtained the assent of the president, the act so passed cannot be held to be unconstitutional on the ground of want of proper assent. This aspect of the matter, as the law now stands, is not open to scrutiny by the courts. In the instant case, the finance bill, which ultimately became an act in question, was a consolidating act related to different subjects, and perhaps the governor felt that it was necessary to reserve it for the assent of the president. We have no hesitation in holding that assent of the president is not justiciable, and we cannot spell out any infirmity arising out of the decision to give such assent. My lord, now your lordships may, my lord, kindly take Kesare Hind, my lord. My lord, this is, my lord, 5-judge bench judgment, my lord. My lord, can I begin at 2? It's almost so that this is a few more paragraphs are to be read in this, my lord.
Your Lordship, may I mention one matter for listing tomorrow? Fresh matter, Your Lordship. There is.
Before Justice Maheshwari, not before this.
Oh, yes.
हेलो
राजेश जी, मैं पुलिस थाने से बोल रहा हूँ।
फिर से?
आप डिजिटल अरेस्ट में हो, दूसरे कमरे में जाइए, अकेले। आपके पार्सल में ड्रग्स मिले हैं, लंबे जाएंगे। 10 लाख दीजिए, बच जाएंगे।
सर इतने कहाँ से?
एक लिंक भेजा है, अभी प्रोसेसिंग के लिए 2 लाख भेजिए, बाकी बाद में।
सर 2 लाख?
क्या हुआ पापा?
बेटा ये कह रहे हैं कि मेरे पार्सल में से ड्रग्स मिले हैं।
अरे
काट दिया।
पैनिक मत कीजिए पापा, डिजिटल अरेस्ट जैसा कुछ नहीं होता है, ये सब फ्रॉड है।
फ्रॉड?
पुलिस, बैंक, आरबीआई इत्यादि के नाम से आने वाले साइबर अपराधियों के फोन या वीडियो कॉल से सावधान रहें। उन्हें कोई पैसे ना भेजें और तुरंत पुलिस में रिपोर्ट करें। अगर समझदारी नहीं दिखाओगे
तो पैसे गवाओगे।
आरबीआई कहता है
जानकार बनिए, सतर्क रहिए।
दोस्तों ओबीसी एनसीएल सर्टिफिकेट केंद्र सरकार वाला बनाने के लिए आपको आना होगा इस वेबसाइट पे। ये सर्विस प्लस का ऑफिशियल वेबसाइट है जो बिहार सरकार के द्वारा जारी किया गया है और यहाँ पे सिर्फ बिहार स्टेट वाले ही फॉर्म को अप्लाई करके बना सकते हैं घर बैठे, कहीं जाने की आवश्यकता नहीं है, खुद से ही आप बना सकते हैं। अब इसको बनाने के लिए आपको फॉर्म भरना होगा, लेकिन उससे पहले आपको एक जरूरी दस्तावेज भी लगेगा। वो लगेगा फ्रेंड्स, ये देखिए फॉर्म 8 आवेदक का स्वयं शपथ पत्र। इसको आपको डाउनलोड करना होगा। डाउनलोड करने के लिए आप यहीं पे देखेंगे तो यहाँ पे एक ऑप्शन मिलता है महत्वपूर्ण डाउनलोड का, इस पे क्लिक करेंगे और फॉर्म 8 पे क्लिक करेंगे तो यहाँ पे ये वाला जो है आपका एक फॉर्म मिलेगा। इसको आप प्रिंट आउट निकालेंगे और यहाँ पे ये स्वयं का शपथ पत्र भी आपको यहाँ पे देना होगा। यहाँ लिखा हुआ है भारत सरकार के परियोजनार। सेंट्रल लेवल की बात करें तो सेंट्रल लेवल वाला ही हम आपको बताना फॉर्म भरना बताएंगे। राज्य वाला कैसे बनता है उसके ऊपर हमने अलग से वीडियो बनाया, वो वीडियो नहीं देखा है तो देख लीजिएगा, लिंक आपको डिस्क्रिप्शन बॉक्स में मिल जाएगा। यहाँ पे अपना नाम लिखेंगे, पुत्र या पुत्री का नाम लिखेंगे और यहाँ पे शहर, पोस्ट ऑफिस, यहाँ पे अपना थाना। अब यहाँ पे अपने पिताजी का नाम लिखना है, पुत्र पुत्री आपका तो कोई होगा नहीं, पिताजी का नाम लिखेंगे और यहाँ पे अपना प्रखंड, अनुमंडल, जिला, राज्य ये सब आप लिख लेंगे। मैं डैश जाति से अपना जाति का नाम यहाँ लिखेंगे और यहाँ पे आप नीचे आएंगे तो यहाँ पे मेरा माता पिता के वेतन से वार्षिक आय, आपके जो इनकम सर्टिफिकेट है उसके अकॉर्डिंग आपकी वार्षिक आय क्या है शब्दों में लिखना है, जैसे 1,15,000, 2,10,000 जो भी है, 3 लाख। इसके बाद यहाँ मेरे माता पिता के अन्य स्रोत से बिजनेस प्रोफेशन सहित कुल वार्षिक आय। अगर आपके पास जो है बिजनेस या कोई प्रोफेशन है आपके माता पिता के पास तो उनका वार्षिक आय क्या है वो शब्दों में लिखेंगे। इसके बाद से यहाँ पे आप देखेंगे इस प्रकार से लिखा हुआ, पढ़ सकते हैं और यहाँ पे अपना हस्ताक्षर करेंगे और यहाँ स्थान अपने गांव का नाम लिख देंगे, यहाँ दिनांक लिख देंगे। इसको क्या करना है फ्रेंड्स, आपको आगे चल के अपलोड करना है। मैं बताऊंगा फॉर्म 8 आपको कहाँ पे अपलोड करना है। इसके साथ आपको आधार कार्ड की फोटोकॉपी, जाति, निवास और आय, ये तीनों चीज आपके पास होगा तो फॉर्म आपका कभी भी रिजेक्ट नहीं होगा। कभी कभी क्या होता है ना, जाति, निवास, आय नहीं आप अपलोड करते हैं तो फॉर्म रिजेक्ट हो जाता है। शपथ पत्र तो अपलोड कर देते हैं, जाति, निवास, आय नहीं अपलोड करते तो रिजेक्ट हो जाता है। तो इसीलिए अगर आपको सही से मतलब इसका बनाना है तो आप जो है जाति, निवास, आय और आधार कार्ड और ये शपथ पत्र, ये सब डॉक्यूमेंट्स के साथ फॉर्म भरेंगे। कभी आपका फॉर्म रिजेक्ट नहीं होगा, आसानी से आपका बन जाएगा और आपका समय बच जाएगा। अब फॉर्म कैसे भरेंगे तो देखिए, इसके लिए यहाँ पे सामान्य प्रशासन विभाग का ऑप्शन मिलता है, इस पे क्लिक करेंगे और यहाँ देखेंगे नॉन क्रीमिलियर प्रमाण पत्र का निर्गमन केंद्र सरकार के परियोजनार्थ, आप इस पे क्लिक करेंगे। अंचल स्तर का ऑप्शन मिलेगा, आप इस पे क्लिक करेंगे। देखिए अंचल स्तर बनने के बाद ही अनुमंडल स्तर पे बनता है, अनुमंडल स्तर बनने के बाद से जिला स्तर बनता है। सबसे पहले आपको अंचल स्तर पे बनवाना होता है। अगर आपका कहीं पे मांग देता है कि अनुमंडल स्तर वाला चाहिए तो पहले अंचल स्तर के बना देंगे, वो बन जाएगा, उसके बाद अनुमंडल स्तर वाला पे आपको क्लिक करके अप्लाई करना होता है। चलिए हम इस पे क्लिक करते हैं। जैसे हम इस पे क्लिक करेंगे आपका जो है आवेदन फॉर्म जो है खुल के आ जाएगा और इसमें आपको अच्छे से जानकारी को भरना है। ये आपका एक ही पेज का आवेदन फॉर्म है, सही से भरेंगे। यहाँ पे आपको पूछ रहा है हिंदी में चाहिए कि अंग्रेजी में चाहिए, तो आप जो प्रमाण पत्र डाउनलोड करेंगे उसका फॉर्मेट यहाँ पूछ रहा है। आप जेंडर बताएंगे, स्त्री, पुरुष, इसके अलावा स्त्री या कोई आवेदन नहीं लेना चाहते तो भी आप यहाँ पे बता सकते हैं। अपना नाम लिखेंगे, मान लीजिए आपका नाम दीपक कुमार है, दीपक लिख के स्पेस देंगे, ऑटोमेटिक यहाँ पे देखिए लिख देगा। कुमार लिख के स्पेस देंगे, ऑटोमेटिक लिख देगा हिंदी में। तो इधर साइड आपका अंग्रेजी है, इधर साइड हिंदी में लिखना है। फिर आपको डेट ऑफ बर्थ की चॉइस करनी है यहाँ से, फिर यहाँ पे आधार संख्या लिखना है। लेकिन ध्यान रखिएगा आधार संख्या अगर आप लिखते हैं तो डॉक्यूमेंट्स अपलोड करने का ऑप्शन नहीं आएगा, उस केस में भी आपका फॉर्म रिजेक्ट हो सकता है। तो आप यहाँ आधार संख्या नहीं लिखेंगे क्योंकि आपको आगे शपथ पत्र अपलोड करना है, आधार कार्ड अपलोड करना है और इसके अलावा जाति, निवास, आय भी अपलोड करना है। तो मैं कहूंगा आधार संख्या नहीं लिखिएगा। अगर आप लिखते हैं तो फिर डॉक्यूमेंटेशन नहीं मांगेगा। अब यहाँ पे आपको अपना स्थायी पता प्रॉपर अच्छे से लिख देंगे, जिला, अनुमंडल, प्रखंड, ग्राम, वार्ड संख्या, पोस्ट ऑफिस, पिन कोड और यहाँ सर्किल नंबर पता है तो लिखेंगे वरना से छोड़ देंगे और यहाँ पे आपको होल्डिंग नंबर पता है तो लिखेंगे वरना से छोड़ेंगे। आप किस प्रकार के लोकल बॉडी से आते हैं, ग्राम पंचायत है, नगर निगम है, नगर परिषद है, क्या है, आप यहाँ से चुनाव करेंगे, उसके अकॉर्डिंग यहाँ पे जानकारी आएगा। पुलिस स्टेशन चूज करेंगे, फिर यहाँ पे आपको पंचायत आएगा, पंचायत चूज करेंगे और अस्थायी पता टेम्पोररी एड्रेस क्या है, यहाँ से आपको राज्य, जिला, अनुमंडल, ब्लॉक, गाँव वार्ड नंबर नहीं पता तो छोड़ सकते हैं, पोस्ट ऑफिस, पिन कोड, सर्किल नंबर पता है तो लिखेंगे वरना छोड़ेंगे, होल्डिंग नंबर पता है तो लिखेंगे वरना छोड़ेंगे। फिर यहाँ पे फिर से पूछेगा स्थानीय निकाय का प्रकार, ग्राम पंचायत, नगर निगम क्या है। फिर यहाँ पे आपको जो है अपना ग्राम पंचायत, धर्म, और यहाँ पे आप अन्य पिछड़ा वर्ग, यहाँ पे देखिए ओबीसी जिसको बोलते हैं। सेंट्रल लेवल पे क्या होता है ना कि बीसी ईबीसी नहीं होता है, सेंट्रल लेवल पे एक ही होता है ओबीसी, अन्य पिछड़ा वर्ग, अदर बैकवर्ड क्लास जिसको अंग्रेजी में बोलते हैं ओबीसी। तो यहाँ पे एक ही ऑप्शन आएगा। अगर वही आप राज्य स्तर पे अप्लाई करेंगे यहाँ दो ऑप्शन आएगा, एक आएगा पिछड़ा वर्ग, एक आएगा अति पिछड़ा वर्ग। तो उसमें से आपको कंफर्म करना होगा कि किस कैटेगरी से आप बिलोंग करते हैं। यहाँ पे आपको अब आएगा जाति, आप किस जाति से बिलोंग करते हैं। तो यहाँ पे वो सभी जाति का नाम शो करेगा जो सेंट्रल स्तर पे ओबीसी के अंतर्गत आते हैं। तो यहाँ पे आप सर्च भी कर सकते हैं इस तरह से। मान लीजिए आप कुशवाहा से आते हैं तो कुशवाहा चूज करेंगे। और भी कोई जाति है, मान लीजिए यादव है तो वाई दबाएंगे तो ये देखिए यादव आ जाएगा। और भी बहुत सारा है, जो भी आप जाति से आते हैं वो अपना यहाँ पे चुनाव करेंगे, आपका यहाँ पे जो शो कर देगा। देखिए इस प्रकार से देख रहे हैं ना। इसकी वजह से आपका कोई उप जाति है तो बताएंगे, नहीं तो छोड़ेंगे। उप जाति क्रमांक पता है तो बताएंगे वरना छोड़ेंगे। पेशा, आप छात्र हैं, सरकारी सेवा, निजी सेवा, व्यापार, किसान क्या है आप अपने अकॉर्डिंग चूज करेंगे। यहाँ पे आपका ये ऑटोमेटिक आएगा, केंद्र सरकार की सूची में आपका क्रमांक क्या है ये ऑटोमेटिक आएगा। फादर नेम यहाँ पे आपको लिखना है और हिंदी में इधर लिखना है। यहाँ पे पिताजी का जाति क्या है यहाँ से बताएंगे। हो सकता है कि आपके पिताजी की जाति दूसरा हो इसीलिए पूछ रहा है यहाँ पे। इसके बाद यहाँ पे उनका क्रमांक जाति ऑटोमेटिक आ जाएगा। फिर यहाँ पे अपना मदर्स नेम और मदर्स का नाम हिंदी में। फिर आप कोई लेडीज है, मैरिड है तो हस्बैंड नेम लिख सकती है। पिता का नाम यहाँ पे, पति का नाम हिंदी में यहाँ पे लिखना है। यहाँ पे आपको ईमेल आईडी लिखना है, यहाँ पे अपना मोबाइल नंबर, और यहाँ पे आपको एक फोटोग्राफ चूज करना है। तो आप हाफ सुंदर सा फोटो जो पहचान हो उस तरह का फोटो आप यहाँ पे चूज करके अपलोड कर लेंगे। इसके बाद यहाँ पे देखिए आपको जो है अभिभावक, पिता, पति की स्थिति। अब यहाँ पे आपको जो है ना इनकम के बारे में जानकारी देना है। मान लीजिए कोई बंदा जो है किसी संवैधानिक पद पे कार्यरत है, उसके पिता हो सकते हैं, उसके माता हो सकते हैं, पति हो सकते हैं। तो ये वाला जो बॉक्स है वो पिता के लिए, ये वाला माता के लिए। तो अगर कोई बंदा मान लीजिए फॉर्म भर रहा है, कोई कैंडिडेट्स है, उसके पिताजी जो है कहीं जॉब कर रहे हैं गवर्नमेंट में, तो यहाँ पे वो पद का नाम लिखेंगे, पद का नाम यहाँ सरकारी सेवा पद नाम, इसके से वेतन, नियुक्ति की तिथि, ये सब आपको बताना होगा। उच्च उम्र, प्रथम श्रेणी की प्रोन्नति के समय क्या था, ये सब आपको बताना होगा। अगर नहीं है तो आप इसे छोड़ देंगे। हो सकता है कि आपके पति, कोई लेडीज है, मैरिड है, तो उसके पति जो है यहाँ पे किसी संवैधानिक पद पे है तो वो अपना यहाँ पे पति का ब्यौरा देगी। नहीं है तो इसे आप छोड़ेंगे। संगठन में कोई काम कर रहे हैं तो संगठन की जानकारी देंगे वरना इसे छोड़ेंगे। निजी क्षेत्र प्राइवेट में काम कर रहे हैं तो प्राइवेट की जानकारी देंगे वरना इसे छोड़ेंगे। तो ये बॉक्स दिया हुआ है पिता के लिए, इधर माता के लिए या पति के लिए। तो हो सकता है कि आपके माता गवर्नमेंट जॉब में हो या आपके पिता गवर्नमेंट जॉब में हो, तो आप उसके अकॉर्डिंग यहाँ पे जानकारी को दे सकते हैं। इसकी वजह से संपत्ति का विवरण भी आपको देना है। पिता का कितना संपत्ति का विवरण है, माता का, पति का। नहीं है तो इसे आप छोड़ेंगे। सिंचित जमीन, आपके पास कितना जमीन है ये बताएंगे। फ्लैट वगैरह ये सब भी है तो पता है, क्षेत्रफल जमीन का सब चीज आपको बताना होता है। नहीं है तो इसे आप छोड़ेंगे। सीधे आप नीचे आएंगे, यहाँ पे जो मैंडेटरी है, सरकारी से कोई आए है तो बताएंगे, व्यवसाय से कोई आए तो बताएंगे, पेशा से, पेंशन से कोई आए है तो बताएंगे, कृषि से कोई आए तो बताएंगे। इस तो जिससे मान लीजिए आपके पास सरकारी से कोई आए तो बता देंगे, व्यवसाय से कोई आए तो आप यहाँ पे क्या करेंगे, लिख देंगे इस प्रकार से। अगर आपके पास मान लीजिए कृषि से आए तो आप कृषि से भी आए यहाँ पे ऐड कर सकते हैं। इस तरह से टोटल आपको यहाँ पे वार्षिक आय शो कर देगा ऑटोमेटिक। आप जो है इनकम टैक्स देते हैं, आयकर का भुगतान करते हैं तो हाँ करेंगे, नहीं तो आप नहीं करेंगे। क्या संपत्ति कर के अंतर्गत आते हैं, अगर आते हैं तो हाँ करेंगे, नहीं तो आप नहीं करेंगे। कुछ अन्य बातें देना चाहते दे सकते हैं वरना इसे आप छोड़ देंगे। अब देखिए यहाँ पे आपके पास जो है ना जाति निवास आय नहीं है तो आप यहाँ पे इन बॉक्स को टिक नहीं करिएगा। जैसे बहुत बार क्या होता है कि बहुत अर्जेंट में लोग बनवाते हैं तो उस केस में पहले से आपके पास जाति निवास नहीं है तो आप इसे जो है अनटिक मतलब टिक नहीं करिएगा। जिनके पास है अगर 100% श्योरिटी के साथ बनवाना है तो इन सबको टिक करके और इसको आगे अपलोड करिएगा तो बेहतर तरीके से बन जाएगा। रिजेक्शन का चांस नहीं रहता। लेकिन अगर आप जाति निवास आय ये तीनों नहीं देते हैं और सिर्फ फॉर्म 8 भी भर के आगे बढ़ते हैं तो 50% चांस होता है कि रिजेक्ट कर दिया जाता है मोस्टली लोगों का, लेकिन 50% चांस है कि बन भी जाता है। अब डिपेंड करता है ऑपरेटर के ऊपर, समझ रहे हैं ना। लेकिन मैं कहूंगा कि जाति निवास आय आप जरूर अटैच करिए, इससे बनने के चांस ज्यादा होते हैं। यहाँ पे आपको जो है ऑफिस का नाम चूज करना है और यहाँ पे आपको सर्किल आएगा, फिर स्टेट आएगा, ये लिखेंगे। फिर डिवीजन यहाँ से आपको चूज करना है अपना, मतलब ये क्या बोलते हैं प्रमंडल आ रहा है तो आप जिस भी प्रमंडल से आते हैं यहाँ चुनाव करेंगे और ओके करेंगे। और जब आप एड्रेस डालेंगे ना तो यहाँ पे ऑटोमेटिक यहाँ पे आ जाएगा, वो सब आपको ओके कर देना है। इसके बाद ऑफिस का नाम ऑटोमेटिक यहाँ आ जाएगा। फिर इस कैप्चा कोड को भरेंगे और सबमिट वाले ऑप्शन पे क्लिक करेंगे। अब अगले स्टेप में यहाँ पे आपको जो है पूरा जानकारी शो होता है कि आप एक बार से जानकारी को वेरीफाई करिए कि हाँ सारा जानकारी सही है कि नहीं है। और इसमें कुछ भी गलती है तो आप उसको सुधार कर सकते हैं। यहाँ देखिए एडिट का ऑप्शन मिलता है, आप एडिट कर सकते हैं। नई गलती है तो अटैच ए नजर पे क्लिक करेंगे। अटैच ए नजर पे क्लिक करते हैं फ्रेंड्स। अब यहाँ पे आपको जो है ना अपना कास्ट सर्टिफिकेट जो है अटैच करना है। अब कास्ट सर्टिफिकेट में आप यहाँ पे जाति प्रमाण पत्र क्या करेंगे, अपलोड करेंगे। यहाँ रेसिडेंशियल निवास सर्टिफिकेट और यहाँ पे इनकम सर्टिफिकेट चूज करेंगे और यहाँ पे ओथ लेटर जो मैंने आपको बताया ना फॉर्म 8 जो कि स्टार्टिंग में बताया कहाँ से डाउनलोड करना है, उसको भरना है, वो आपको यहाँ पे अटैच करना है। और ये सब डॉक्यूमेंट्स 200 KB से कम होना चाहिए, PDF में चलेगा। और यहाँ पे दस्तावेज में आधार कार्ड या इसमें से कोई एक ID प्रूफ आप क्या करेंगे, चुनाव करेंगे और उसको फाइल को चूज कर लेंगे। सारा का सारा डॉक्यूमेंट जो है 200 KB से कम होना चाहिए, PDF में होना चाहिए और उसके बाद से सेव एनेक्सर पे क्लिक करेंगे, ये डाटा सेव होगा। जितने भी डॉक्यूमेंट्स आप अटैच करके सबमिट करेंगे, अब यहाँ पे फिर से प्रीव्यू आएगा, फिर से जानकारी को वेरीफाई करिए कि सारा जानकारी सही है। अगर इसमें गलती है तो एडिट कर सकते हैं, नहीं तो यहाँ पे सबमिट का ऑप्शन मिलता है, सबमिट करेंगे, आपका जो है यहाँ पे फॉर्म सबमिट हो जाएगा। ये देखिए आपका फाइनल प्रिंट आउट यहाँ पे आपको मिल जाएगा और यहाँ पे आपको जो है बताया गया कि कितना दिन के अंदर ये आप जो है प्रमाण पत्र बन जाता है और यहाँ पे आपको कब जो है प्रमाण पत्र बन जाएगा तो आप इसे डाउनलोड कर सकते हैं। इसके लिए आपका यहाँ पे डेट और टाइमिंग सब चीज लिखा रहता है, सेवा प्रदान करने की प्रस्तावित तिथि जो
पुलिस
मिस सीमा
जी,
अभी पुलिस स्टेशन आई है। रुकिए वरना घर आ जाएंगे।
क्यों? लेकिन मैं
अकेले दूसरे कमरे में जाइए। आपका बेटा हमारे कस्टडी में है और आप डिजिटल अरेस्ट में हो।
डिजिटल अरेस्ट?
1 लाख दो, बच जाओगे।
इतने पैसे?
अच्छा ठीक है, एक लिंक भेजिए, अभी प्रोसेसिंग के लिए 30,000 दो, वरना बेटा जेल जाएगा।
जेल तो तुम जाओगे, तुम्हारा चेहरा रिकॉर्ड हो चुका है।
अरे
डिजिटल अरेस्ट जैसा कुछ नहीं होता, ये सब फ्रॉड है, इसीलिए पैनिक ना करें। पुलिस, बैंक, RBI इत्यादि के नाम पर आने वाले साइबर अपराधियों के फोन या वीडियो कॉल से सावधान रहें। उन्हें पैसे ना भेजें और तुरंत पुलिस में रिपोर्ट करें।
हेलो मम्मा।
RBI कहता है
जानकार बनिए, सतर्क रहिए।
there is nothing so stable as change. It's behind every one of us, in every act, every thought, every breath, and every achievement. Intelligence is the ability to adapt to change, to know where to go, what paths to take, to become responsible and to understand everything that this implies. Because one change always leaves the way open for the establishment of others. And more changes, and more changes. We are all part of these changes together. A sense of compassionate collectiveness that will lead us towards a better world, creating a boundless drive that we'll be able to share, nourish, and spread. Education is the most powerful weapon which you can use to change the world. More than a mere engagement, it's a promise to learn, to create, to discover, and to understand how to make good choices tomorrow. So, as Gandhi said, let's be the change we wish to see in the world.
नमस्कार दोस्तों, यदि आप बिहार के एक नागरिक हैं और आप BC EBC कैटेगरी से बिलोंग करते हैं तो आप सभी को मैं बता दूं, किसी भी प्रकार की सरकारी फॉर्म अगर आप भरेंगे ना तो उसमें आपसे बोला जाता है कि आप अपना NCL सर्टिफिकेट की जानकारी दीजिए, क्योंकि BC EBC वालों को जो है NCL सर्टिफिकेट बनाना होता है। अगर बिहार लेवल का कोई फॉर्म भरते हैं तो बिहार वाला ही NCL सर्टिफिकेट से काम आपका चल जाता है। वही अगर आप सेंट्रल लेवल का कोई भी फॉर्म भरते हैं तो आपको सेंट्रल लेवल वाला NCL बनाने होते हैं। तो इस वीडियो में मैं आपको बताने वाला हूँ कि बिहार का अगर कोई भी फॉर्म आप भरते हैं तो उसमें जो NCL सर्टिफिकेट मांगी जाती है तो NCL सर्टिफिकेट कैसे बनाना होता है, NCL सर्टिफिकेट से क्या आपको फायदे होंगे और NCL सर्टिफिकेट किनको बन सकता है, इसे कैसे डाउनलोड करना है, सारा प्रक्रिया इस वीडियो में बताई गई है। वीडियो को ध्यानपूर्वक अंत तक देखें, पसंद आ तो इसे लाइक और दोस्तों के साथ शेयर करें। ऐसे लगातार अपडेट के लिए चैनल को सब्सक्राइब करें ताकि आगे भी इस प्रकार की जो भी अपडेट होगा ना आपको मिलता रहेगा। सबसे पहला डाउट आपका क्लियर करते हैं, ये NCL सर्टिफिकेट होता क्या है। देखिए NCL सर्टिफिकेट मैंने बताया ना कि सभी लोगों का नहीं बन सकता है। NCL सर्टिफिकेट सिर्फ बिहार में जो BC EBC वाले होते हैं उनका बनता है। NCL सर्टिफिकेट एक प्रकार से समझिए कि आपका जो आरक्षण का जो दावा आप करते हैं ना उसका बेनिफिट आपको दिलवाता है। अगर इसको आप नहीं बनाकर नहीं लगाते हैं तो जो भी आरक्षण का बेनिफिट अगर आपको मिलना होगा ना वो आपको नहीं मिल पाएगा, ये ध्यान रखिएगा। एनसीएल सर्टिफिकेट वैसे अगर देखा जाए तो ये 1 साल तक वैलिड होता है। आप 1 साल में आप नया बना सकते हैं। अगर 1 साल से ज़्यादा पुराना हो चुका है तो मैं कहूँगा कि नया ही बनाकर कोई भी फॉर्म भरे ताकि आपको उसका बेनिफिट मिल पाए। दूसरी चीज़ है कि एनसीएल सर्टिफिकेट बनाने में आपको जाति, आवासीय आय और साथ में आपको आधार कार्ड की आवश्यकता पड़ेगी, ये ध्यान रखिएगा। तो पूरी प्रोसेस अभी मैं अपने स्क्रीन पर चलकर बताता हूँ कि कैसे एनसीएल सर्टिफिकेट के लिए ऑनलाइन अप्लाई करना है। वीडियो को अभी तक लाइक नहीं किया तो लाइक कर दीजिए और चैनल पर नए हैं तो सब्सक्राइब जरूर कर लीजिए। इस प्रकार की लगातार अपडेट आपको आगे भी मिलता रहेगा। आइए फिलहाल स्क्रीन पर चलकर पूरी जानकारी बताते हैं।
There is nothing so stable as change. It's behind every one of us, in every act, every thought, every breath, and every achievement. Intelligence is the ability to adapt to change, to know where to go, what paths to take, to become responsible, and to understand everything that this implies. Because one change always leaves the way open for the establishment of others. And more changes, and more changes. We are all part of these changes together. A sense of compassionate collectiveness that will lead us towards a better world, creating a boundless drive that we'll be able to share, nourish, and spread. Education is the most powerful weapon which you can use to change the world. More than a mere engagement, it's a promise to learn, to create, to discover, and to understand how to make good choices tomorrow. So, as Gandhi said, let's be the change we wish to see in the world.
इसके लिए सबसे पहला काम करें, अपने मोबाइल या लैपटॉप में गूगल ओपन करें। गूगल में लिखना है RTPS। यह वेबसाइट serviceonline.bihar.gov.in का मिलेगा। इसे ओपन करेंगे। उसके बाद यहाँ पर देखेंगे ना ऑनलाइन आवेदन दे में काफ़ी सारे ऑप्शन मिलते हैं। जहाँ पर आप देखेंगे सामान्य प्रशासन विभाग का एक ऑप्शन मिलता है, इस पर क्लिक करना है। यहीं से आप आवासीय प्रमाण पत्र, आय प्रमाण पत्र, जाति प्रमाण पत्र बना सकते हैं। इसके अलावा नॉन क्रीमी लेयर प्रमाण पत्र भी है और ब्रैकेट में लिखा हुआ है बिहार सरकार के परियोजनार्थ। इसका मतलब बिहार लेवल का बनाना है तो आपको यहाँ पर क्लिक करना होगा। एक है केंद्र सरकार के परियोजनार्थ, मतलब सेंट्रल लेवल वाला बनाना है तो यहाँ से बनाएंगे। EWS बनाना है तो यहाँ से बनाएंगे। तो इस वीडियो में मैं आपको NCL बनाना बिहार लेवल वाला बता रहा हूँ। तो जो ये ऑप्शन दिया गया है बिहार सरकार का परियोजनार्थ, जिस पर क्लिक करेंगे। अब NCL सर्टिफिकेट भी 3 स्तर से बनता है। पहला अंचल स्तर, अनुमंडल स्तर, जिला स्तर। अब आपको देखना है कि किस स्तर से आपको बनाना है। अंचल स्तर से भी अगर बनाते हैं तो बिहार की कोई भी भर्ती होती है तो उसमें ये जो NCL सर्टिफिकेट है वो वैलिड होता है, ये ध्यान रखिएगा। तो पहला स्टेज आपका NCL सर्टिफिकेट अंचल स्तर से ही बनना चाहिए। आप अंचल स्तर पर आपको क्लिक करना है। जैसे ही आप क्लिक करेंगे ना आपके सामने ये फॉर्म खुलता है, जिसमें सबसे पहला पूछा गया है कि क्या आपके पास पहले से निर्गत प्रमाण पत्र है। तो अगर पहले से NCL बना है तो आप यस कर सकते हैं, अगर नहीं बना है तो नो कर देंगे। आपका जेंडर क्या है, लड़का है तो पुरुष, लड़की है तो स्त्री, आप यहाँ से सेलेक्ट करेंगे। बाकी कोई अभिवादन अगर आपका है तो आप बता सकते हैं, मतलब श्री, श्रीमती, ये सब अगर लगा है तो ठीक है, नहीं तो कोई अभिवादन नहीं आप डालेंगे। बाकी कैंडिडेट का नाम क्या है, जिनका भी आप जो है NCL बना रहे हैं उनका नाम लिखेंगे और यहाँ पर ऑटोमेटिक हिंदी में आ जाएगा। जैसे मैं एग्जांपल के लिए किसी का नाम मान लीजिए सीता है, सीता लिखकर जैसे ही स्पेस दिए ना तो यहाँ पर हिंदी में आ गया। अब डेट ऑफ बर्थ आपका जो भी है ना, कैलेंडर मिलता है, पहले जो भी साल आपका हो उसको चयन करिएगा, जो महीना हो, जो डेट हो, इस प्रकार आप चयन करेंगे। बाकी यहाँ पर पूछ रहा है कि आपके पास आधार कार्ड है तो यहाँ पर आधार नंबर देंगे। आधार नंबर देंगे तो आधार से लिंक नंबर पर OTP जाएगा, उसको वेरीफाई करना होगा। अगर आप नहीं देते हैं तो बाद में आगे चलकर आपको आधार कार्ड को अपलोड कर देना है, उससे कोई दिक्कत नहीं है। अगर आप देना चाहे तो दीजिए, नहीं देना चाहे तो छोड़ सकते हैं। फिर नीचे आएंगे, आपका जो भी आवासीय पता है ना उसकी जानकारी देना है। तो यहाँ पर आपका जो भी राज्य है बताएंगे, जो भी आपका डिस्ट्रिक्ट पड़ता है बताएंगे, जो भी आपका अनुमंडल पड़ता है वो बताना है, जो भी आपका प्रखंड पड़ता है उसको आपको यहाँ पर बताना है, जो भी आपका विलेज पड़ता है बताएंगे, वार्ड नंबर बताएंगे, थाना बताना है, जो भी पोस्ट ऑफिस है बताना है। और यहाँ पर देखिए होल्डिंग नंबर, ये उनके लिए होता है जो शहरी क्षेत्र के लोग होते हैं, तो है तो ठीक है, नहीं तो छोड़ सकते हैं। इसके अलावा देखेंगे ना सर्कल नंबर है तो ठीक है, नहीं तो छोड़ दीजिए। उसके बाद जो भी आपका पिन कोड है आपको यहाँ पर देना है। आप जो बिलोंग करते हैं वो ग्राम पंचायत में आता है, नगर निगम में आता है, नगर परिषद में आता है या नगर पंचायत में आता है, वो बताएंगे। और जो भी जैसे मैंने ग्राम पंचायत चुना तो मेरा जो भी ग्राम पंचायत है बताएंगे। नगर निगम चुनेंगे तो जो भी नगर निगम है उसकी जानकारी हम देंगे। अब यहाँ पर पूछ रहा है कि जो ऊपर दिया गया पता और टेम्पोररी पता अगर दोनों समान है तो इस चेकबॉक्स पर टिक करेंगे, दोनों ये फिलअप होगा। अलग अलग है तो अलग अलग जानकारी को फिल करना है। फिर यहाँ पर देखिए आपसे रिलीजन पूछता है, किस धर्म से बिलोंग करते हैं उससे आप बताएंगे। किस कैटेगरी से आप बिलोंग करते हैं अपना कैटेगरी यहाँ से बताएंगे। उसके बाद आपका जो भी जाति है यहाँ से सभी जाति का नाम मिलता है, अपना जाति का नाम लिखेंगे। उपजाति आपका कौन सा है वो आपको यहाँ से बताना है। अब उसके बाद आपसे ऑक्यूपेशन पूछ रहा है कि मतलब क्या करते हैं आप। अगर स्टूडेंट है तो स्टूडेंट बताएंगे, गवर्नमेंट सर्विस में है, प्राइवेट सर्विस में है, कोई बिजनेस करते हैं तो आप अपने अकॉर्डिंग जानकारी को बताएंगे। पिताजी का जो भी नाम है लिखना है, यहाँ पर हिंदी में देखने को मिलेगा। कोई शादीशुदा महिला है तो उनके हस्बैंड का जो नाम होगा लिखेंगे, यहाँ पर हिंदी में देखने को मिलेगा। यहाँ पर माता जी का नाम लिखना है। आपका जो भी मोबाइल नंबर है वो मोबाइल नंबर देंगे। आपका जो भी ईमेल आईडी है आपको यहाँ पर ईमेल आईडी देना है। फिर आपको नीचे स्क्रॉल कर आना है। यहाँ पर पूछता है कि अभिभावक, जिसमें आपके पिता पति की जो भी स्थिति है बताएंगे। ये कॉलम आपके पिता के लिए है या आपकी माता के लिए है या आपका पति के लिए है, जिसमें आपको जानकारी देनी होती है कि आपके पिता, माता या पति जो है संवैधानिक पद पर है तो आप बता सकते हैं। जैसे मान लीजिए अगर पिता है तो वो बताएंगे, अगर माता है तो माता वाले कॉलम में बताएंगे और पति है तो पति वाले कॉलम में बताएंगे, जिसमें पद का जो भी नाम है। उसके अलावा सरकारी केंद्र जो है ये केंद्र या राज्य वाला है वो आपको बताना है, पद नाम बताना है, वेतन बताना है। अगर ऐसा है तो, नहीं है तो इसमें कुछ करने की जरूरत नहीं है, आपको नीचे स्क्रॉल कर आना है। आपको यहाँ पर देखिए पूछता है कि आय के बारे में जानकारी दीजिए। आय जो आपका है इनकम वो कितना है, सरकारी नौकरी से आय कितना है तो यहाँ पर बता सकते हैं। व्यवसाय से कितना आया है, पेंशन से कितना आया है। इसके अलावा यहाँ पर पूछ रहा है कृषि से कितना आया है, वो आपको यहाँ पर बताने की जरूरत होगी। तो आपका वार्षिक आय यहाँ पर देखने को मिलता है। फिर यहाँ पर पूछता है कि क्या कर भुगतान करते हैं, यानी जो है विगत 3 वर्षों से इनकम टैक्स फाइल करते हैं तो इस करें, नहीं तो नहीं वाले विकल्प पर आप क्लिक करेंगे। बाकी अन्य जानकारी है, अगर आप इसमें कुछ बताना चाहे तो बता सकते हैं, अन्यथा छोड़ेंगे। अब नीचे आएंगे ना तो इस फॉर्म को जब भी आप सबमिट करते हैं तो कुछ डॉक्यूमेंट आपको देने होते हैं, जिसमें देखिए सबसे पहला है फॉर्म 11 जो कि एक शपथ पत्र है, उसको भरकर अपलोड करना है। उसके अलावा आपको जो है यहाँ पर देखिए बोला गया है कि आपको आवासीय प्रमाण पत्र देना है, जाति प्रमाण पत्र देना है। इसके अलावा जो भी आपका जो है आय प्रमाण पत्र है उसको आपको देना है। अब आप कहेंगे ये फॉर्म 11 जो है ये मिलेगा कहाँ, तो मैं इसका लिंक आपको दे दिया हूँ डिस्क्रिप्शन में। यही फॉर्म है जो कि आपके शपथ पत्र है। इसमें देखिए बहुत ही सिंपल चीज है, इसमें कुछ ज्यादा भरना नहीं है। आपका जो नाम है ना, नाम भरेंगे, जो भी आप पुत्र पुत्री जिनका भी है, यानी आप अपने अभिभावक का नाम लिखेंगे, अपना गाँव का नाम लिखेंगे, अपना पोस्ट ऑफिस लिखेंगे, थाना लिखेंगे, प्रखंड लिखेंगे, अनुमंडल लिखेंगे और जिला यहाँ पर लिखेंगे और राज्य यहाँ पर लिखना है। इसमें बताना है कि मैं जो भी जाति से बिलोंग करते हैं अपना जाति का नाम लिखिएगा। उसके बाद यहाँ पर आपको आना है। उसके बाद यहाँ पर देखेंगे ना 4 नंबर में पूछ रहा है कि मेरे माता पिता की वेतन से वार्षिक आय, यानी अगर मान लीजिए जॉब में है आपके माता पिता, उससे कुछ इनकम आ रहा है तो बताए, नहीं तो यहाँ शब्दों में बताना है। तो अगर नहीं है तो यहाँ पर आप लिख सकते हैं 0। उसके अलावा पूछ रहा है कि माता पिता की जो अन्य स्रोत है ना उनसे वार्षिक आय क्या है, मतलब जो आपके इनकम सर्टिफिकेट बना होगा ना कितना का है वो आपको यहाँ पर शब्दों में लिखना है। फिर नीचे आपको आना है, यहाँ पर स्थान लिखना है कि ये फॉर्म आप कहाँ से भर रहे हैं, साथ में डेट आपको लिखना है। और उसके अलावा यहाँ पर आवेदक है या लड़की है तो यहाँ पर आवेदक को काटकर आवेदिका वो हो जाएगी, तो उनका ऊपर में सिग्नेचर करा दीजिएगा। तथा नाम भी है तो यहाँ पर ऐसे नाम कर उनका जो भी नाम है ना यहाँ पर आपको लिख देना है। तो इसको भरकर आपको अपलोड करना होगा।
There is nothing so stable as change. It's behind
अब एक चीज और ध्यान रखिएगा कि जब भी आप मोबाइल नंबर देते हैं ना, तो आपके नंबर को वेरीफाई भी करना होता है। तो उस पर ओटीपी जाता है, उस ओटीपी को यहाँ पर आपको फिल कर क्या करेंगे, वैलिडेट करेंगे, आपका जो ये नंबर है वेरीफाई होगा। तो उसके बाद इसमें देखेंगे ना, एक और डॉक्यूमेंट आपसे पूछता है कि अगर आपके पास है तो इसको भी अटैच जरूर कर दीजिए, जैसा सिंचित जमीन का प्रतिशत बिहार सरकार के सीलिंग कानून के अंतर्गत, मतलब अगर आपके पास कोई जमीन का ये है न रसीद उसीद, तो उसको भी आप अटैच कर दीजिएगा। नहीं है तो आप चाहे तो इसको छोड़ सकते हैं। बाकी इस कैप्चा कोड को फिल कर प्रोसीड करना है। उसके बाद आपके सामने फॉर्म का प्रीव्यू आता है, एक बार जानकारी को देखें और एक ऑप्शन मिलता है अटैच इंस्ट्रक्चर का, जिस पर आपको क्लिक करना है। अब देखिए यहाँ पर वही डॉक्यूमेंट सब आपको देने होंगे, जैसे शपथ पत्र जो आपने भरा है, मैंने अभी बताया 11 वाला फॉर्म 11, उसको सेलेक्ट कर पहले उसको अपलोड कर दीजिएगा। इसके अलावा आपका जो भी आवासीय प्रमाण पत्र है उसको यहाँ पर अपलोड करना है। जो भी आपका इनकम सर्टिफिकेट है उसको यहाँ से आप अपलोड करेंगे। जो भी आपका कास्ट सर्टिफिकेट है ना उसको अपलोड करेंगे। और अन्य डॉक्यूमेंट में आप इनमें से कोई डॉक्यूमेंट जैसे आधार कार्ड हो, वोटर आईडी कार्ड हो, उसको सेलेक्ट कर उसको आप अपलोड करेंगे और सेव इंस्ट्रक्चर पर क्लिक करेंगे। उसके बाद आपके सामने फॉर्म का फाइनल प्रीव्यू आएगा, उसमें एक बार जरूर अपनी तमाम जानकारी देखें। सभी जानकारी सही है तो सबमिट वाले विकल्प पर क्लिक करना है। इस प्रकार देखेंगे ना, आपका जो फॉर्म है सक्सेसफुल सबमिट होगा। किस डेट को फॉर्म सबमिट हुआ है वो पता चलेगा। और 21 दिनों का समय ये लगता है आपकी सर्टिफिकेट को बनने में। तो 21 दिन बाद जो आपको ये प्रमाण पत्र मिलेगा वो कब मिलेगा और डेट भी आपको मिल जाता है। अगर इसको डाउनलोड करना है तो यहीं से एक्सपोर्ट टू डाउनलोड पर PDF पर